You've been working on your book for months, maybe even years, and someone published something almost identical. Can they do that? Now, under copyright law, they generally can. That answer might make you angry, but it could also save your business. Because your book idea, the concept, the topic, the title, under current US copyright law, none of that is eligible for copyright protection. But before you panic, there are 4 things that generally are protected. And if you set these 4 things up right, you build a legal foundation that is difficult for anyone to challenge. Today, I'm walking you through what copyright law actually protects, the biggest mistakes that authors make with their intellectual property, and the 3 steps that give your book real legal protection. Now stay with me, because the 3rd step is the one most authors skip, and it changes everything. If we haven't met, I'm Ellie Shefi, attorney, strategist, and founder of Made to Change the World, a publishing house for mission-driven leaders. I'm a 12-time #1 international best-selling author with over 30 years of experience across law, business, education, and advocacy. My background is in intellectual property, and this is one of the most common gaps I see in how authors protect their work. Let's start with the hard truth. Your title? It's not eligible for copyright protection. Your topic? Also not eligible. Your general premise? Not eligible either. Under copyright law, ideas themselves are not protectable. Only the specific fixed expression of an idea qualifies for protection. Now that means that someone can hear your concept for a book about leadership lessons from trauma survivors and write their own version. Under copyright law, that's generally permitted. Now, they can't copy your exact words, they can't lift your sentences, but they can write about the same topic in their own voice with their own stories. I know it feels wrong. You've invested months, maybe even years developing your concept. But this isn't a reason to panic. It's a reason to get strategic. Because while your idea is not protectable, your expression of that idea generally is. And that's where smart authors build their advantage. Now, here are the 4 things copyright law generally does protect, as long as you created them and they contain sufficient original expression. Number 1, your specific words and sentences. The particular language, phrasing, metaphors, and analogies you use to express your ideas. Now, under copyright law, that original expression is generally protected. Nobody can copy your actual text without potentially infringing on your copyright. That's why your voice matters. How you say something can be just as important as what you say. Number 2, your unique structure and arrangement. The way that you organize your chapters, the sequence of your arguments, the framework you use to walk readers from problem to transformation. If you've built a proprietary structure, a step-by-step system, a signature methodology, that specific arrangement may qualify for copyright and trademark protection. Number 3, your named framework. Now this is where it gets real for entrepreneurs. Let me be specific, because people mix up the terminology all the time. Your methodology is your process. It's that step-by-step system that you teach. Your framework is the structure you organize it into. For intellectual property purposes, it's important that you name your system. So under copyright law, the actual steps and ideas inside a method, they're not copyrightable. That's Section 102B of the Copyright Act. Processes, systems, and methods of operation themselves are excluded from copyright protection. But the specific way that you express and teach your proprietary system in your book, that is generally protected by copyright. And the name you give your method, the branded identity of your system, that may be eligible for trademark protection. A generic concept like mindset coaching is not protectable. But a uniquely branded framework with specific language, a distinctive name, and original structure, that can generally be protected through both copyright and trademark. One of my authors recently came to my best-selling book bootcamp with deep expertise, but no clear framework. Working together, we changed that. She said I helped her figure out what her actual methodology is and what her business is actually based on. We structured her methodology, named it, and built the book around it. Her book became a #1 international bestseller. And it was powerful because the framework was clear, and the framework gave readers something to remember and refer back to. It's important. Number 4, your human authored manuscript. Now this is critical, so pay close attention here. Copyright protection requires human authorship. If a human created the work, that work is generally eligible for copyright registration. Whether it's your first draft, your final draft, your notes, your outline, all of it can be copyrighted. On March 2nd, 2006, the Supreme Court refused to hear the case Thaler versus Perlmutter. Now, that case involved AI-generated art where the creator listed his AI system as the author. The Copyright Office, the District Court, and the Appeals Court all said no. He could not claim ownership of the AI-generated art. And the Supreme Court declined to hear the case, thereby upholding the law as it now stands. Now, under current law, human authorship is the bedrock. It is required for copyright protection. Now, here's what that means if you're using AI in any part of your book writing process. Under current law, AI-generated content that lacks sufficient human authorship is not eligible for copyright protection. Period. And here's another wrinkle that most authors don't think about. Content that you've released into the public domain before you've copyrighted it is also not eligible for copyright protection. Anyone can use it, copy it, republish it, and there's nothing you can do about it. Now, I want to be clear about the risk here. This is not about having a weaker copyright claim. If your content does not qualify for copyright protection, either because it was AI generated or because you inadvertently released it into the public domain, your content is not protected and anyone can use it freely. The bottom line, human authorship is the foundation of copyright and there is no shortcut around it. If you want copyright protection for your book, the authorship must be yours, and you cannot have already released it into the public domain. And here's something that most authors aren't paying attention to. In 2025, authors sued Anthropic, one of the largest AI companies in the world, alleging that it had trained its AI on over 482,000 copyrighted books without permission, many of which were obtained from pirated book repositories online. That lawsuit led to a reported $1.5 billion settlement, one of the largest copyright settlements in US history. That case makes one thing clear. Your published work has real value, and AI companies know it. That's why protecting your authorship and your copyright registration matters more than it ever has before. And if you're an author and you're not paying attention to how your work is being used, you may be leaving yourself exposed. And if you're writing a business book right now, I made a video about the #1 mistake that business owners make when writing their book. I'll link it right here. If you're finding this video helpful and this is your first time here, this channel is for mission-driven leaders, speakers, authors, coaches, and consultants who want to turn their expertise into a book that actually builds their business and their legacy. If that sounds like you, welcome! Subscribe and hit that bell so you don't miss what's coming next. Now that you know what's protected and what's not, let's talk about what to do about it. Because understanding the law is only step 1. You need a strategy. Now, step 1, use NDAs before sharing your work with anyone. Before you hand your manuscript to an editor, a beta reader, a collaborator, or a business partner, get a non-disclosure agreement in place. Now here's why. Since ideas are not copyrightable, your idea is not protected under copyright law. But an NDA creates the basis for a separate breach of contract claim. That's a different legal avenue, and it gives you protection for your confidential concepts and your proprietary content that copyright alone does not provide. Now, no legal document guarantees that someone won't take or misuse your work, but a well-drafted NDA establishes a clear obligation of confidentiality, and it creates a documented basis for a claim if that obligation is violated. A straightforward NDA covering confidentiality and restricting the use of your proprietary content, it's generally sufficient. Now, step 2, name, copyright, and trademark your framework. If you have a signature methodology, a step-by-step process, a branded system, give it a name, and then protect that name. A uniquely branded methodology name may be eligible for trademark protection as a service mark. A generic description? It's not. The name is what you trademark. The specific way you express and teach your system in your book is what you copyright. Together, they give you a stronger legal foundation than either one alone. Now, that's exactly what we work on at my best-selling book bootcamp. Framework naming is one of the first things we do because your book, your brand, your business model, it's all built on top of it. You can find the link in the description below. Step 3, publish first and publish strategically. The first person to publicly establish authority in a space creates a documented, time-stamped record of their expertise that is difficult for anyone to replicate after the fact. When you publish a strategically positioned book and you promote it through media, speaking engagements, and your social media platforms, you build a public record. Your copyright registration date, your publication date, your media appearances, that documented record supports your ownership claim and makes any challenge later much harder to sustain. This is one of the biggest reasons I tell my authors, do not sit on your manuscript. The longer you wait, the more time someone else has to establish authority in your space. Recently, one of my authors came to my best-selling book bootcamp, not knowing where to begin. She had a general concept for her book, but she had no idea she could have her actual manuscript and business plan done in less than a week. She followed the process. We published her book, and her book became a #1 international bestseller. Her published book, her copyright registration, her public appearances, all of that now creates a documented record that supports her as the originator of that work. So let me bring this all together. Your book idea, it's not protected under current copyright law. Your book title, not protected either. Your topic, also not protected under current copyright law. But your specific expression, your structure, and the name of your framework can generally be protected by copyright and trademark. Remember to get an NDA before sharing your work with anyone. And if you're using AI in your creative process and you want to protect your work, remember that the authorship itself must be yours. And you can't release it into the public domain, whether intentionally or accidentally, before you have copyrighted it. Now, whether you're writing your first or next book, or you're regrouping after a publishing experience that didn't go the way it should have, remember to build your book around a clear, named framework, protect the name, and get your book published and out into the world. If you're not sure where to start, I have a free masterclass that walks you through what it takes to write and publish a book the right way. That link is in the description below. And be sure to watch this next. I made a video about the key things to check before you sign with any publisher. Because knowing what's protectable means nothing if you sign away your rights in a publishing agreement. Your copyright, your subsidiary rights, your royalties, your ownership of the manuscript files. Publishers can slip clauses into contracts that mean you hand it all over. Don't fall for it. Now, that is a must-watch video, and I'll link it right here. In my next episode, I'm going to be talking about how to prove you wrote your book, because proving authorship is a critical foundation of every copyright claim. If you don't want to miss it, subscribe and hit that bell. Remember, you were made to change the world. Now go do it. I'm Ellie Shefi, and I'll see you in the next video.